And as we've submitted in our heads, whilst international law recognizes the principle of state immunity, its breadth and its extent is always a matter of domestic law. And that's precisely the finding made by the Canadian Court in Schreiber versus Federal Republic of Germany, Both parties agree that states are generally entitled to immunity in respect of acts jure imperi. Those are sovereign acts. That is the approach taken by the United Nations, European and draft inter-American conventions, the national legislation in those states which have adopted statutes on the subject, and the jurisprudence of national courts. It is against that background that the court must approach the question raised by the present proceedings, namely, whether that immunity is applicable to acts committed by the armed forces of a state and other organs of that state acting in cooperation with the armed forces in the course of conducting an armed conflict. It is against that background that the court must approach that particular question in the present proceedings, whether immunity is applicable to acts committed by the armed forces of a state in the course of conducting an armed conflict. Germany maintains that immunity is applicable and there is no relevant limitation on that immunity to which a state is entitled in respect of acts jure imperi. Italy, in its pleadings before the court, maintains that Germany is not entitled to immunity in respect of the cases before the Italian courts, and then it sets out the reasons for that. But that's critical, because it says the only question it has to ask is immunity when there's an armed conflict, wartime. And if that wasn't clear, at page 174 of the core bundle, at paragraph 65, the court makes it absolutely clear what it's there to decide. It says, beginning at 174, at the foot of the page, the court considers that it is not called upon in the present proceedings to resolve the question whether there is in customary international law a tort exception to the state immunity applicable to acts in iure imperii in general. The issue before the court, I'm now at 175 of the core bundle, is confined to acts committed on the territory of a foreign state by the armed forces of a foreign state in the course of conducting an armed conflict. Again, about war. That's absolutely decisive, because the ICJ tells you that we are asking one simple question: does state immunity extend when two countries are at war with one another? That's the only question it was answering. And then the court goes on to explain at paragraph 70 of its judgment, which is at 177 of the core bundle. Does an examination of what the law is on this particular question. And then it says, what have other countries actually done about territorial torts? And it says at paragraph 70, turning to state practice in the form of national legislation, the court notes that 9 of the 10 states referred to by the parties which have legislation specifically for the subject of state immunity have adopted provisions to the effect that a state is not entitled to immunity in respects of torts occasioning death. Same with Forsyth, same with our argument. Then it refers to a number of statutes and one particular point. All of these countries say, if you commit a tort within our borders, it doesn't matter that you're a foreign state. Why? Because it's not an act of sovereignty. War is an act of sovereignty, but torts are not. So the simple point we make about Germany v. Italy is that its conclusions are narrow. It is about the question of immunity in armed conflict, not broader than that, and the court makes that expressly clear. That's what it's dealing with. So the respondent's placement, or reliance rather, on Germany v. Italy is misplaced. That case does not stand for a general bar on territorial torts. On the contrary, it confirms, in reference to the 10 states that it looks at, that there are countries who say, if you commit a tort here, it doesn't absolve you from liability within our territory. And there cannot be a very serious suggestion that when this happened against the Nama and OvaHerero, that these were people engaged in an armed conflict with the state. Cannot be. It was a genocide par excellence. I'm told I need to rush up. I've got 25 minutes, so I'll try and go as fast as I can. On the last few submissions, I'll be brief so that Mr. Kauta can deal with the other issues.
There is at least consensus from the respondent papers. That's what I see, that immunity is not absolute. They make that acknowledgement in their heads. But notwithstanding that, they go on to say that Germany is still immune on the basis of state sovereignty. And reference is made to the German-Italy matter. They also refer to the inter-sales research matter. I didn't hear you on that matter. The inter-sales research and development services matter.
I must admit that judgment doesn't spring to my mind, my Lord.
It's in paragraph 36 of their heads.
36.
Yeah, 35, 36. That's where they deal with this issue. You may proceed and perhaps come back to it.
Yes, my Lord, if I could do that and reply and deal with that. Yes, I mean, it seems that we are on all fours. If I'm reading this correctly, I'll deal with it properly in reply. but the proposition that they underline in paragraph 36 is that the proposition that in international law, that the doctrine of absolute sovereign immunity is outworn and spent, and that it has been replaced by the restrictive doctrine in which no immunity is conferred in respect of commercial, is fully supported by modern writers. Yes, I think we agree on that. The difficulty with the, Justice Bear, the difficulty with the arguments as we understand it of the respondents is they accept that immunity is not absolute. Then they say, well, what tells you how to decide this question? And they say Germany v. Italy. But I've already demonstrated that Germany v. Italy doesn't assist because Germany v. Italy expressly says that territorial torts does not extend to state immunity. So they rely on it, but it doesn't support them. And when I deal with the other judgments that they rely on, I'll demonstrate that even those particular reliances are incorrect. Banker Bush, they try to distinguish Banker Bush, which is a topic I'm going to turn on to next, by reference to the judgment of the South African Supreme Court in East Asian Consortium versus MTN Group. Then they say the arrest warrants case, but the arrest warrants case is about personal immunity. But they haven't cited a single authority, with the exception of Germany v. Italy, that says our argument about territorial torts is wrong. Now, turning to Banker Bush, which is a judgment, and we refer to it in our heads, and I won't repeat the submissions in view of the time limits. The court in Banker Bush makes a fundamental distinction in paragraph 37. And here's what the UK Supreme Court says there. It says that the fundamental difference between parties to this appeal concerns the starting point, which seems to be our difference in this case as well. On the footing that customary international law must require the United Kingdom to treat Libya and Sudan as immune, the Secretary of State submits that it does. This is because in his submission, state immunity is absolute unless the case is brought within an internationally recognized exception. This submission, if it is correct, would considerably broaden the scope of state immunity in customary international law. But in my view, it is not correct. The rule of customary international law is that a state is entitled to immunity only in respects of acts done in the exercise of sovereign authority. In the absence of some special rule to some different effect applicable, that is the default position. He says the default position is immunity only extends to acts done in the exercise of sovereign authority. Anything outside of that, game fair. Fair game. So I won't repeat it because we rely on it in our heads and given the time limits, but the thrust of the point in Banker Bush is this. Territorial torts fall outside of the hardcore acts of sovereign acts. And we say that that is why the Namibian courts must follow a similar approach. We've relied on the judgment of the KwaZulu-Natal High Court in South Africa in Malone versus Government of the United Kingdom. And there, similarly, a tort had been committed by the UK government. There was action proceedings that were instituted. They raised an exception that they are immune from the authority of the South African courts, and the court says, no, you aren't, because you committed a tort. And that approach is followed again in South Korea, in Brazil, in Italy, and we've provided in our core bundle a journal article that explains this particular development in the law. The court will find that particular article, I won't go to it, at page 784 of the core bundle. Apologies. No, my lady. Indeed. It's at the core bundle page 26 to 50. It's an article from the International Criminal Law Review entitled State Immunity and the Victim's Right of Access to Court, Reparation and the Truth. And there, the article speaks about how territorial torts have been applied in South Korea, in Italy, as well as in Brazil. And in all three judgments, the court says one thing. Again, if you commit a tort in our territory, you're not immune. Now, on the last 2 points, the respondents seem to say, Banker Bush, in their heads of argument, they say, Banker Bush was not dealing with state immunity, it was dealing with acts of the state. And it says, look at the judgment of the South African Supreme Court in East Asian Consortium versus MTN that explains the distinction. I won't spend much time on that. The simple point is this, that is not true. Simply not true. The court will find one reference in all 46 pages of the Banker Bush judgment to the words acts of state. The entire judgment is about state immunity. Paragraph 1 of that judgment begins with, the issue before this court is about state immunity. Then the court, Lord Sumption, goes through a whole development about how state immunity has developed over time, and then he makes those particular conclusions at the end that says, and I've read some of them, if you commit a tort, you're not immune. So there's no issue, there's absolutely no reference to acts of state in that particular judgment, barring that one reference in the entire judgment. The second is in East Asian Consortium versus MTN. Again, that distinction is not set out at all. In fact, there's no reference at all to Banker Bush. And if the court looks at the heads from the respondents, they simply say East Asian Consortium sets out the distinction. They cite the entire judgment, don't point you to a single paragraph that says that, not one, because it's not there. But even if East Asian Consortium is of application, the court need only look at the following paragraphs in the judgment, because it is a very long judgment. Paragraphs 56 and 57. There the Supreme Court says, there's no need to join the state of Iran to this dispute because it has no legal interest in the dispute. It says it's a purely commercial fight between two parties. Why should Iran be before the court? That's a trite principle of joinder. And then secondly, at paragraph 63, the court then refuses to join Iran because it wasn't a necessary party to the dispute. That's all that East Asian Consortium says. So it neither reclassifies Banker Bush, distinguishes Banker Bush, explains what acts of state are, because Banker Bush doesn't do that. That's really the point. Lastly, on the Hughes Kogan's argument, there's a confusion here by the respondents' argument. They seem to be laboring under the impression that we're saying, because it's a Hughes Kogan's violation, the court should overlook all principles of state immunity. That's not our position at all. We're saying the court must apply state immunity as it's set out in customary international law, as it's set out in the common law, as it's set out in ICJ decisions. We're not seeking an exception. We're saying apply it as it is. The only point we make about the Hughes Kogan's argument is this. The ICJ, at paragraph 58 of its judgment in Germany v. Italy, says when a court is confronted with the question of immunity, what law does it apply? Does it apply the law of immunity as it stood at the time when the offense was committed? Or does it apply the law of immunity as it stands today? And it says, at paragraph 58, that when you come to the question of immunity, it is a procedural question of law that the court must apply in relation to the law as it stands on the day in which the proceedings are launched. You don't apply the question of immunity in reference to what the position was then. Then what we say, relying on that particular distinction the ICJ makes in Germany v. Italy, that what is the question about the law on immunity in relation to genocide? And we then turn to the Genocide Convention. And we refer the court to two articles in the Genocide Convention, Article 4 and Article 6. And both make one point. If you are accused of genocide, you are not immune. That's what the Genocide Convention says. Immunity cannot be raised as a defense to a genocide charge. So what we say is the ICJ says you apply on the question of procedural law the question of immunity, the law as it stands today. The law as it stands today is that the Genocide Convention says immunity cannot be raised in response to a genocide charge. That's all we say. We don't say the court must carve out an exception. We say apply it as it is. So, my lady, with those particular submissions, we simply submit that the court must apply immunity as it is, must apply the law as it is. There is no statute regulating this because there's a clear distinction between the two, and we're not seeking any exceptions whatsoever. With the time left, I don't know how much time I have left, with the court's leave. Yes, it's Justice Fair.
Your concluding remarks was that where there's an accusation of genocide, then a state is not immune. What are we here for today?
Oh, we're here purely on a joinder of two issues.
Yes.
The joint declaration, which the applicants are seeking to set aside, and the second is the declaration of genocide against the state of Germany.
Are you saying that is what we are here for today?
No, not today at all. So let me be clear, that is the relief that the applicants are seeking.
That's the ultimate
That's
relief
the
in the
ultimate
main
relief the applicants are
application.
seeking. Yes. And to get to that particular relief, we say that Germany needs to be joined because they have an interest in those particular issues, the two issues. The question before the court today is purely a question of about whether it has jurisdiction over Germany. If we are correct about our submissions on the position under international law, on territorial torts, the court doesn't even have to go as far as the Genocide Convention at all. But we're simply responding to the argument that seems to be a confusion in the respondents' heads.
Court decide the joinder issue today, even though Germany has not been served.
That's precisely what the edictal service application seeks to achieve.
But you haven't made mention of the edictal citation as such.
Yes, no, because both cases, the edictal citation application and the joint application, turn on the question of jurisdiction. The court doesn't have jurisdiction. There's no point in serving on Germany. And so we have to come past that hurdle first before the court can decide on the merits of the edictal citation application and the joint.
Would you agree that if the court is with the applicants, that this court does have jurisdiction? Would you agree that for the time being, you would be given leave to sue by edictal citation through serving the joinder application on Germany? Once that is done, there isn't a joinder yet. That Germany should then be given an opportunity to oppose the joinder, should they so wish. And the court would then only hear the joinder application.
Justice Diaga, yes, absolutely. You look at what we seek in the notice of motion. I can take the court to it so that we're clear about the relief that the applicants are seeking. So in page 764,
Bundle.
Sorry, this is now in the main pleadings bundle.
Yes, but
Yes.
which
Page 764.
part 7 or part what of the bundle?
Apologies, my lady.
Which part?
I'm just trying to get clarity about which part. Just a moment, my lady.
Just repeat the page number, please.
764.
It would be in bundle part 8.
Part 8. Thank you, my lady. I'm indebted to the court. So the notice of motion in the edictal citation application reads, 1, that leave be granted to the applicants to effect service of the joinder application against the sixth respondent by way of edictal citation under Rule 12 of the rules of this honourable court, and then it sets out how that service will be effected. The embassy will assist, newspapers, the usual. So, Justice Siaka, yes, absolutely.
But the problem is that the joinder application is also before court today.
Yes.
So my question would be that if the court is with the applicants on jurisdiction, joinder cannot be ordered today.
No,
Only edictal citation.
yes, I think that would be absolutely correct, because obviously Germany has to be given an opportunity to say its side. The government respondents, as I understand it, don't speak for Germany. They're absolutely correct about that. They've come here to assist the court with those particular submissions about jurisdiction in particular. But because the question of edictal citation also turns on jurisdiction, we have to come past the jurisdiction point.
Yes, of course. But if we would get there, and Germany would come and say that they do not agree and they would oppose on the basis of jurisdiction, just getting from the starting blocks, jurisdiction will then have to be considered again.
Yes.
Whatever finding that the court may make in respect of the edictal citation application, for example, saying that prima facie there is jurisdiction, it does not mean that Germany will not have that opportunity to again raise it, as you have also indicated in your heads of argument that sovereign immunity is to be raised by the entity relying on it,
yes,
to say why they are immune.
Yes, yes. No, Justice Iago, we would have no issue with that. We're certainly not seeking to foreclose the opportunity of Germany to raise whatever arguments it wishes to. If the court thinks it's too premature to join Germany to these proceedings, because it has to have an opportunity to argue whether the court has jurisdiction or not, that order would be, we would have no issue with that kind of order. But the difficulty is, you would have seen from the application for edictal citation that we tried to serve in the ordinary way in terms of Rule 12. And we were told, in the absence of court order, we're not going to assist you, and so we have to bring the application. But to surmount that, we have to obviously make arguments on jurisdiction, even if the court forms a preliminary view on that issue.
One more concern. What is the standing of this joint declaration? The whole relief sought is to try and set aside the joint declaration. What is its standing, and is it worth to be entertained and be set aside? I want to hear what your views are.
Yes, that's the relief that we seek in the main proceedings. Certainly the arguments made by the respondents, as we understand it, because they filed an answer to it, is your application is premature, it's not a final agreement, etc. And we disagree with that, and we have various reasons for that. It's a similar argument raised in another matter which I was in against former President Zuma before the Constitutional Court of South Africa, in which he had similarly made a decision and had withdrawn South Africa from the SADC tribunal, and he argued that the actual issue was premature because if the decision had not been effected on the other end, and the court rejected that argument squarely. But that's an argument for the main case, for the merits of that particular dispute, the prematurity of the relief that we're seeking. But it is not an issue that the court needs to decide now. The court is only called to purely decide these procedural issues before we get to the main dispute.
The court got the distinct impression that the applicants are of the view that an edictal citation is not applicable in this matter, and that another procedure should be used. The process set out in Rule 11 instead of Rule 12.
I can happily deal with that in reply. If that's the impression we make, I just need to clarify that. That's certainly not my understanding. I could be completely wrong. But I'll rely heavily on Mr. Kauta, who is an expert on
It's
on
a
the High
reciprocal
Court.
service of civil documents.
Yes, yes.
That more applies instead of edictal citation.
Yes, I'll happily deal with that in reply. Maybe Mr. Kauta can deal with it briefly, should it become a sticking issue, but it's certainly not my impression of it. If the court has no further questions on that, if I could give Mr. Kauta some time to deal with the irregular step proceedings, I'm indebted to the court.
Okay. Then, Mr. Kauta, thank you.
Thank you, Madam Maniji. 3 minutes, and I'll deal with the issue of irregular step within 3 minutes. the court will note that the issue is dealt with from page 702 of the pleadings bundle. I believe that will be the 8th part of the bundle. But I will take the court simply to, in the answering affidavit of the, that was served by the government respondents at page 554, paragraph 7, they raise the issue that the Prime Minister and the Minister of Defense were not joined to the proceedings, and that is fatal. It's important.
The page again, please.
Page 554, paragraph 7 is the answering papers of the government respondents. They raise that issue. If the court goes to page 702, that deals with the Rule 61 application. Prayer 1 thereof is a condonation application for bringing the Rule 61 application late. We say with respect, if one reads paragraph page 712, paragraph 61, paragraph 6.1, paragraph 6.2, and paragraph 6.3, the only defense proffered within Rule 32.9 is that we should seek leave in terms of the Kapia judgment. The joinder application is important. We say for purposes of determination of the Rule 61 of the Rule 61 and Annexure A in particular at page 842 up to page 843. If one excludes Germany for present purposes, the parties are at Eden that 27 institutions must be joined. I include in the 27 the Prime Minister and the Minister of Defense. Yet, this issue we submit turns on Annexure BS4 at page 862. Part 8, I'm informed. That is the if my lady is there, if the court is there, the court will notice that that is the Okanjode group, Okanjode Chiefs Assembly on Genocide letter. Most importantly, at the bottom thereof, the court will notice that it constitutes out of 8 chiefs. But important for the irregular step is at page 863, at the bottom thereof, where that institution says that we totally reject the negotiation process that has resulted in the joint declaration because it does not address the issue of restorative justice and reparation. We make that point because the government respondents at paragraph 5 at page 554, it's important to go to...
Just a second, you're referring to page 863.
Page 863.
I'm not seeing what you're reading on page 863, Mr. Carter.
Part 9, my lord.
Yes, I'm page 9.
Is it under number 1?
Under number 1, my
I
lady.
see. I see. All right. Thank you. I'm with you.
Yes, and we make that point because of what the Minister of International Relations and Trade says at page 900, and from page, her affidavit is at page 905. I believe that will be part 9 as well. Part 10, I am told. Specifically, if the court goes to page 907, paragraph 4, she says, on 8 May 2025, the applicants filed an application for the joinder of several respondents and an application in terms of Rule 61. The state respondents oppose the application under Rule 61. Counsel for the state respondents will file heads of argument in accordance with the directions issued by the court in its order of 14 May 2025. Paragraph 5, I have read the notice of motion and the supporting affidavits filed by the applicants in support of the joint application on several respondents, including the Federal Republic of Germany. I record that the state respondents do not oppose the joint application and submit that it must be determined in accordance with the law. Most importantly, and I will show now as paragraph 6, the second line, where the minister says any allegation made in the applicant's supporting affidavits that is not specifically traversed, the state respondents reserve the right to respond to those allegations in the main application in the event that the proposed respondents are joined. Now we know that there is no issue with respect to joining the chiefs. We uploaded a judgment.
If it may help, my lady, we do not oppose that joinder. Can go through.
Yes, but the point I'm making is specifically made in paragraph 77 of the AGM judgment. That is at paragraph, at page 40 of that judgment, where it says there is no provision in the rules for a respondent in motion proceedings to deliver supporting papers, thereby making itself in effect a co-applicant. If a respondent wishes to be a principal party in obtaining the relief sought by the applicant, it should apply to be joined as a co-applicant so that the other respondents in the matter can answer the case put up by it, so that the exchange of papers and subsequent hearing can proceed in a structured manner contemplated by the rules. On any approach, a respondent which chooses to act as if it were a co-applicant must expect to find itself treated as a co-applicant for cost purposes should any of the opposing respondents ask for a cost order against it. The point we're making is that if the application for joinder is to join at least the 27 respondents where there are no issues as respondents. But if one reads BS4 that I've taken the court to, those 8 chiefs will have to make an election even after being joined, whether they are going to join and argue the issue that they're saying at page 863, in which event they will have to bring an application to be co-applicants. For that reason, the joinder being the rationality of joining entities is for them to be heard. They will not be heard if they are simply joined as respondents. If they will be deprived the right to raise the issue at page 863 at BS4. For those reasons, we submit, we do not depart from our heads of argument. We have submitted, we just add this proposition to our heads of argument on irregular step, as it pleases the court.
I think it's time for the respondents now.
Yeah. Are you done, Mr. Kaufler?
I'm done, ma'am. With the court.
Thank you.
I'm indebted to the court.
Mr. Isco?
Perhaps we should start off and ask why we're here. And I can give the answer from this document. It reads as follows. In 1904, Germany waged the war which annihilated large part of indigenous communities that were residing in what is now Namibia. General issued an order on the 2nd of October 1904, which led to the death and suffering of thousands of OvaHerero, including women and children. Controta then issued a second order in 1905. This was directed against the Nama and also threatened them with a similar fate. Eventually, after many, many years of the government trying to get restorative justice, as it is put, there is a good chance that Germany apologizes and bows before the descendants of the victim. I've read to you, my lord and my lady, from the draft joint declaration. That is a process with which government has now been dealing with for more than 2 decades. When it reaches the stage of being noted only in Parliament, this application is brought by, amongst others, Mr. Swartbooi. Now he wants the noting of this tremendous work. At last, some of these victims may obtain some justice. What does Mr. Swartbooi do? He wants to set it aside. What will happen after that, only he will know. And that is what the main debate is. Now, in this process, other people must or may be joined, but the issue then becomes, what about Germany? Now that Germany has a direct and substantial interest in the matter, there is no debate about it. The question is this: what can the court do on an international plane, on international Namibian rights, if the court does not have jurisdiction over Germany? And with respect, I heard Justice de Jager asking a question on prima facie jurisdiction. There is no such a thing, with respect. There is either jurisdiction or not jurisdiction. Because Germany, as it did in Italy versus Germany, will not come, will not join, because their view is and will be as it was in Italy versus Germany. So there is only one question which this court must answer, and that is, has a case for edictal citation been made out? And again, the first question to answer is, does the court have jurisdiction? It's not substituted service, it's edictal citation, which is based on jurisdiction. That much recently, Mr. Justice Masuku set out in the Google matter, which we also refer to in our heads. Absent jurisdiction, there is no edictal citation. And we submit then, my lady and my lord, two principal reasons why this court can simply not issue edictal citation. And the first one is the Act 71 of 1951. It is called the Diplomatic Privileges Act. Now, the Act says save as provided in Section 2 of the Act. Save as provided in Section 3, the following persons shall be immune from the civil and criminal jurisdiction of the courts of the territory. And it continues, and if you go to after F, and all legal process sued out against the persons or property of such persons shall be void. Now, I need here to stand still a moment and just refer the court also perhaps to the last section of the Act which repealed what was previously repealed. And if you go to those Acts of 1932, 1934, and 41, you will immediately see in those acts, which were also Diplomatic Immunity Act, the concept head of state was not found in there, in those old Diplomatic Immunities Acts. It is the first time in this Act of 1951 that the concept head of state was inserted. Now, I have made, and I'm going to apologize, we can also upload it, but it would be better if I hand to you hard copies of a few additional authorities. Yes.
Closing counsel. Thank you. We will, however, ask that it be uploaded. For purposes now, the hard copies are useful, but it will please be uploaded.
Thank you, my lady. So, we have actually emphasized, not confused, that there is a difference between head of state immunity and diplomatic immunity. A head of state immunity, you have books just written on head of state immunity. It's a separate thing than diplomatic immunity. Heads of state are normally not coming to live in consuls and so forth. So, what is a head of state? And why do we say it doesn't matter that the applicants in this matter sued or cited the government of the Federal Republic of Namibia? Because that's avoiding, because they could have said, we cite the president or whoever the head of state is of the federal government of Germany. Then the act would have been applicable. But what they're trying to do is to avoid the act by citing the government. Now, my lord and my ladies, in international law, governments on an international plane do not have personality. It is the state which has the personality. And it is for that reason why we refer you to Holsbury's Laws of England, 5th edition, and over the page, at page 3 of the bundle, it says, just before the footnote, as a state is represented in its international relationship by its government, and the acts of each government counts as the acts of the state for the purpose of international law. But it is on the international legal person of the state, not its government, that the international law confers rights and imposes obligations. So I will refer you in a moment to an English case which the judge criticized the applicant for trying to avoid the provision head of state by citing someone else. And this is what we say is not of assistance. If the right person was cited here in his official capacity, in other words, the head of state, like we sue sometimes in Namibian law, the Prime Minister or the President of the Republic of Namibia, that is what should have happened here. You cannot operate on an international plane by playing games with words. That's the only issue. And if the head of state may not be sued as prohibited by this act, then there cannot be an edictal citation application which is successful. And much has been said about the subordination argument. All it says is, Article 144 says all law, customary international laws shall be applicable, but importantly it says subject to the provisions of this constitution and legislation. Now, as soon as legislation is applicable and the act on which we rely is applicable, edictal citation is prohibited. Yes, in that sense, we may be outdated on 1951 laws, but that is the law as we find it, and that is the law which the court will have to apply. Now, I also refer you to page 5 to the case in the middle there, Propend Finance Pty versus Singh, where His Lordship says the protection afforded by the Act of 1978, that's now the UK Act, to states would be undermined if employees, officers, or as one authority puts it, functionaries, could be sued as individuals for matters of state conduct in respect of which the state they were serving had immunity. Section 14(1) must be read as affording to individual employees or officers of a foreign state protection under the same cloak as protects the state itself. So if our Act speaks of a head of state, and you could sue the head of state, that head of state in his capacity as leader of the state on an international plane pleads lack of jurisdiction. Or in this case, with reference to the Act, points towards the Act and say, you may not. In 1971, at page 7, in the case of Parkin, an application was made to attach property of Congo Fundandam jurisdictionem. The court then looked at our act that which we deal with here, and I'll just read to you, the court says, the immunity provided for in section 2 of Act 71 for heads of state a fortiori applies to foreign sovereign states in international law. That's exactly what our argument is and what we say. The head of state there in our Act prohibits this application from going out to invade the space of the foreign country. That is what comity is in our nations. And that is what you cannot prima facie give them a chance. It is our call. It is this country's call. And we are here, and I will show you, to avoid, with respect, the same order against Namibia, which the ICJ ordered against Italy. Because you will not see in any of those cases, my ladies and my lord, where people were sued in Italy, in Germany, in Italy, where the German state opposed, like here. The first time they come on the scene in international law is when the state's arm, with respect in the form you represent today, breaches that international obligation. Then we are in the ICJ, not these courts. That's how the system functions. There was some debate about the section in the Act which says the minister must publish. We respectfully submit the names. So, in the matter of clear, your ladyships and your lordship will recall, Justice Masuku says, it is not important, it's helpful, but it's not a validity requirement for the name to be published. The name of the head of state, or just if it says head of state of Germany, will be good enough. But that is in any event so. I think, with due respect, I shouldn't think, but perhaps one must remind yourself what was happening in 1951. The news then came by steamboat. It wasn't pressing Google who's the head of state. So if someone was walking around in South Africa or the territory then, and he was arrested, it would have been helpful to have a government gazette at hand to the policeman. Today I will say, look at Google. In fact, I'm not even sure whether we knew how many states there were in 1951. Perhaps that in itself would have become an issue from time to time. Remember, that was few years after the Second World War. They were still developing states, making new ones, breaking old ones up in wherever they were busy negotiating. So, but in any event, the judgment of Parkin, the judgment of Penrose at 10B, just want to refer your ladyships and your lordship to that. In the Parkin matter, the Penrose matter, there as from E to H, the point is made that even if there is no publication in a gazette of a specific name, then it's not a proposition that does not give anything, because the court says at G, prima facie, there seems to be much to be said for this proposition. It is certainly so in England, and it has been decided that inclusion or omission from official lists is not conclusive of the status of the de cuius. So, we have never said that diplomatic immunity and state immunity are the same thing. In fact, we have said the contrary. Our argument was always that the act, yes, it's called diplomatic immunity, but you can call a bus a plane, it will remain a bus. So if it deals with state immunity or head of state immunity, the act is applicable. And that is also then the end of the first portion of the argument. I move on to the ICJ case.
The applicant cited the Federal Republic of Germany in a manner to circumvent the Diplomatic Privilege Act. will the argument still be the same, even considering that the joint declaration that is sought to be set aside refers strictly to the government of Germany and the government of Namibia?
No, it will exactly be the same. There's a distinction on the organ acting, my lord, that's the government, and the person or state that is recognized in international law, that is the state. But states are like companies, they've got no body to kick or soul to condemn, they must act through people. All I'm saying is you cannot circumvent the Privilege Act by calling the state another name by its government. Now, I'm going to refer you now, my lady and my lord, to the ICJ case because it is so important. But before I do so, I respectfully ask that you first set down the important paragraphs, because it seems that there is some either misunderstanding or not reading of some of these paragraphs. And they are in the judgment itself, and I'm referring to the majority judgment. Paragraph 21, 23, 27, 40, 55, 56, 61, 65, 77, and 78. That's the first portion of the argument. Then the gravity defense, or gravity, or the exclusion they say to seek on the property or a delict within the state. That's paragraph 82, 84 to 85, 87 and 90. And then lastly, I'll refer you to paragraphs 93 and 95. But before I do so, may I just say this, and it is important for understanding and making a decision on this case. I must repeat, unfortunately, there is no such a thing as prima facie jurisdiction at this level.
Clarify something. It's now the third time that you mention it. The issue was raised in the context of the procedure adopted by the applicants to bring the joinder application first and then only the edictal citation application. And bringing a joinder application, you must serve on the party to be joined for them to say something if they want to. They did it the other way around. So it was in that context that I said that should they succeed, as in any other edictal citation situation, the person then coming to court would always be able themselves to raise jurisdiction again. And it must then be determined again, which the fear is, what would be the situation if you then have a conflicting judgment?
I recall your lady exactly, but I thought that they saw this as an out. You did say, should you succeed? That was your first words. But all I'm emphasizing is, in this international context, plane where you're dealing also with jurisdictional issues and sovereignty and so forth, it's not like a normal party process. It's either yay or nay. And that is all I'm emphasizing. Okay, that was then the first point. The second issue here is there is a huge difference between criminal jurisdiction at an international law plane and civil jurisdiction. The exception which the applicants want to invoke with reference to the convention, the torture convention and the genocide convention, refers to an obligation on states who are parties to it to stop those crimes, to punish those people, and to assist for them to go to, and my learned friend was correct when he used the words charge. That's the exception, charge. And it is in that context where genocide plays such an important role. In fact, it is the reason, and the only reason, why Pinochet was extradited. Because the UK Supreme Court said, otherwise it would have been a no, because of your immunity, albeit at that stage to a person. But it is only because of the genocide convention which all the parties signed, which took it out. In any event, the genocide convention or the genocidal law was by then jus cogens long time ago. So I'll come back to that paragraph. Then
also address, with the dictal citation, the requirement looking at the nature and extent of the claim that would lie against the person to be brought to court. To what extent should the court go into looking into that in respect of the particular relief being sought in the main application, with reference to they aren't being brought to the Namibian court to be charged for anything? Or
no, they asked to, sorry my lady, what they say, or Mr. Swartbooi say, and I submit does not say it's pretend, it's political music. He wants to bring Germany here to set aside a joint declaration, not even signed yet, but simply one that was noted. And then for that purpose, he now invokes a host of constitutional provisions to say, substantively, it is also bad. Just the noting of this. What he does not say is, of course, what will happen if such an order is given. Must all the Herero nation and the Nama nation, must they start the whole process up front? Or what is it that he wants to achieve?
perhaps I'm not entirely clear. If there was a final joint declaration, and if the relief was to bring Germany here to enforce that declaration, to pay for their dues, so to speak, it would perhaps be more understandable than what they are seeking is exactly the opposite, to set it aside, for there to be nothing for the time being. So what will they be doing here? So looking at the nature and extent of the claim, the requirement for edictal citation, how and how far should the court go into the nature of the main relief being sought?
But as a general rule, lady, you will look at the relief which is now set out, which may be obtained at some stage. Is there a prima facie case made out for that? That's all it is. But again, we didn't concentrate on that question for today because we must first cross the first hurdle of jurisdiction and immunity. Now, if I may then ask you to I'm going to refer you now to the paragraph, and this might take a while, I apologize, but for us it is very important. First paragraph which we refer to, 50. Oh. The first one is actually paragraph 21 and 15. So, to the judgment paragraph. And it's important to understand also why we are here. Because if I may just ask your ladyships and lordship to look at paragraph 16, eventually what did Germany ask the International Court of Justice to declare? It says Germany praised the court to adjudge and declare that the Italian Republic, by allowing civil claims based on violations of international humanitarian law by the German Reich during World War II from September 43 to May 45 to be brought against the Federal Republic of Germany, committed violations of obligations under international law in that it has failed in respect to respect the jurisdictional immunity which the Federal Republic of Germany enjoys under international law. This is after the Italian courts permitted on all kinds of exceptions which were argued like we hear today. Eventually those people succeeded, and they actually also executed some of the judgments. And this is what Germany ended up with, or Italy rather. It was said, your judicial branch are making international law transgressions. That, with respect, is why we are here. Then at paragraph 21, I'm not going to read everything, but importantly, there's some distinction made about the gravity of offenses, or the gravity of the delict, so to speak. But there, the court describes the atrocities committed by the German forces. Then your ladyships and your lordship will see there was the peace treaty of 1947, and then over the page in 1953 the first compensation was paid by Germany. At paragraph 23 you can have a look at that. And then there's more and more and more and more payment. And eventually, people are still not satisfied, and they then sue like they want to sue here now. Because I hope eventually that if Germany does what it exactly did in this case with Italy, if Germany does with our two nations, treat them the same, then they will get paid. And hopefully Germany will not turn around and say, but I'm doing my best to get restorative justice. Then Swartbooi comes and set it aside. I'm turning to at 52, paragraph 52, you can just make a note there again. The court describes the elementary considerations of humanity which was breached by Germany in the war. And then at paragraph 55 and 56, at 53, 54, and 55, that is important. I'll read you paragraph 56. Although there has been much debate regarding the origins of the state immunity and the identification of the principles underlying that immunity in the past, the International Law Commission concluded in 1980 that the rule of state immunity had been adopted as a general rule of customary international law solidly rooted in the current practice of state. That is the status of the rule of immunity. That is what the ICJ tells us. So the rule exists. What do we read in the respondents' heads? They say, let's put shortly. There is no rule, there are only exceptions. Whenever you read in the heads of argument of put shortly, then you must know with respect to check the authority, because it's making shorts.
The respondents are your clients.
Sorry, the applicant. I'm indebted. Then, in paragraph 57, the court, this is the court now saying, the court considers that the rule of state immunity occupies an important place in international law and international relations. It derives from the principle of sovereign equality of states, which, as Article 2 of paragraph 1 of the Charter makes clear, is one of the fundamental principles of the international legal order. You can continue to read further. Then I'm going to turn, eventually when they now answer the question, is at 77. Huh? 75. Apologize. Huh? Yes, 77. The court answered this question. The court, in the court's opinion, state practice in the form of judicial decisions supports the proposition that state immunity for acta iuri imperi continues to extend to civil proceedings, and importantly, for acts occasioning death, personal injury or damage to property committed by the armed forces and other organs of state in the conduct of armed conflict, even if the relevant acts take place on the territory of the forum state. That practice is accompanied by opinio juris, as demonstrated by the proposition or the position taken by the states and the jurisprudence of a number of national courts, which must have made clear that they considered that customary international law required immunity. The almost complete absence of contrary jurisprudence is also significant. You can continue to read. I'm turning to 78. This is the conclusion. In the light of the foregoing, the court considers that customary international law continues to require that a state be accorded immunity in proceedings for torts allegedly committed on the territory of another state by its armed forces and other organs. I think Lothar van Trotta was an armed force of another organ in the course of conducting an armed conflict. That conclusion is confirmed by the judgment of the European Courts of Human Rights, to which the court has referred. The court therefore concludes that contrary to what had been argued by Italy in the present proceedings, the decisions of the Italian court to deny immunity to Germany cannot be justified on the basis of the territorial port principle. Now, that's what the ICJ says, not what my learned friend submitted. It said, what did the applicants now do? They say, let's turn for the answer to Forsyth. And they're quite correct, Forsyth deals with international private law. And then Forsyth says there is an exception based on the territorial tort principle. But it is so important to remember about which country Forsyth writes. He writes about South Africa. And it is because South Africa has an act, the State Immunity Act, Section 11, which says so. That's where the Maloney judgment comes in. Is it Section 11? Which says that's the exception to the rule. Now, what I've read to you now is international customary law on immunity at paragraph 78. Of course, a state like South Africa can make an exception by writing Section 11, the exception or the territorial tort exception, into their legislation. But we are not litigating in South Africa. We're litigating in Namibia with Namibian legislation, and there's nothing of that sort in our law. Then you will recall that the next was the gravity issue. Now, the gravity issue refers to the nature of the tort or the crime. I'm not sure how to express myself on that, but to say that a very serious torture may take you out the exception. But the ICJ deals so beautifully with it at paragraph 82 of the judgment. You will see there they deal with the gravity of violations. It says, at the outset, however, the court must observe that the proposition that the availability of immunity will be to some extent dependent upon the gravity of the unlawful act presents a logical problem. Immunity from jurisdiction is an immunity not merely from being subjected to an adverse judgment, but from being subjected to the trial process. It is therefore necessary preliminary in nature. Consequently, a national court is required to determine whether or not a foreign state is entitled to immunity as a matter of international law before it can hear the merits of the case brought before it and before the facts have been established. If immunity were be dependent upon the state actually having committed a serious violation, then you've got the cart before the horses, basically says the ICJ, because every time to see whether the exception of this grave crime is applicable, you'll have a 10 years trial to determine whether there is such a huge violation so that you can have jurisdiction. Now, the minority judgment of Justice Azar is held by the applicants and also held by many over the world. But the problem is, and the solution is, the ICJ had spoken on it. And he suggests, Justice Azar suggests, that there should be a balancing exercise. But that balancing exercise runs directly into this logic of the ICJ, to look at the merits to determine whether you have jurisdiction. That is then at 82, I'm now at 84. Now they come and they say, in addition, there is a substantial body of state practice from other countries which demonstrates that customary international law does not treat a state's entitlement to immunity as dependent upon the gravity of the act of which it is accused, of the peremptory nature of the rules which it's alleged to have violated. And then there is there's too many authorities quoted to prove the point. And then in this judgment, at paragraph 87, what did Italy do? They rely on Pinochet. But the court says quite correctly, the court does not consider that the United Kingdom judgment in Pinochet is relevant, notwithstanding the reliance placed on that judgment by the Italian court in Ferini. Pinochet concerned the immunity of a former head of state from criminal jurisdiction of another state, not the immunity of the state itself in proceedings designed to establish liability to damages. It seems, with due respect, once we have studied ourselves in here, someone in this application of Mr. Swartbooi took this case and just repeated Germany's arguments, despite the fact that they were roundly rejected in 2012 already. Why does he do that? I turn to paragraph 90, 15 minutes. Paragraph 90, the European Court of Human Rights has not accepted the proposition that states are no longer entitled to immunity in cases regarding serious violations of international humanitarian law or human rights law. Then it refers to two cases, one from the Grand Chambers and the other one from the court itself. Then over the page at paragraph 92, you recall this argument again of jus cogens as the exception. Here is the answer in paragraph 93, sort of in the middle of the page. It says the rules of state immunity are procedural in character and are confined to determining whether or not the courts of one state may exercise jurisdiction in respect of another state. They do not bear upon the question whether or not the conduct in respect of which the proceedings are brought was lawful or unlawful, or how unlawful, or how serious. Again, a point raised by the applicants. And paragraph 95 then concludes, to the extent that it is argued that no rule which is not of the status of jus cogens may be applied to do would hinder the enforcement of a jus cogens rule. Again, this comprehensive judgment gives the answer. So, at the end of the day, where are we? We came here after a long process that this government followed to bring help to its people. They were there, the history is recorded in the papers. Then, on the day that at last some compensation may come to the Herero and Nama people, Mr. Swartbooi wants to set it aside. For some reason now he wants to join Germany to make politics. But he faces the hurdle of immunity. What does he do when he faces that? He takes the judgment of the highest court in the world and twists every argument, which was already rejected. And he brings us here. That is not how the people should be assisted by him. We have not come here, we say again, to defend Germany. We have come here on the question of the court to protect Namibia from being put in the position where Italy found itself, where the ICJ says, listen, you are in breach of your international obligations. And we don't want to become the pariah state of what South Africa was until 20, 30 years ago. So that concludes. I ask that the edictal citation application be dismissed, and I ask with costs of 1 and 2 counsel, although we more, only 1 and 2. Then as far, my ladies and my lord, the issue of the irregular proceedings is concerned, I have only one submission to make. It is, again, unnecessary. The affidavit of my clients were filed in terms of a court order. The court order says file on that day, then my clients do just that, and they call it irregular. That's just impossible. It's as good as saying, if the court tells me that I can go and fetch someone things to sell on execution and it's a lawful sale and execution, that I'm acting irregular. I'm not. I'm acting in terms of a court order. How difficult is that now? That application must also be dismissed with costs and only on a limited scale of 20,000. May I just... Those are the submissions, my lady.
Thank you. Mr. Ramachali, before you reply, I think we're just going to take a 10-minute health break. And then we will return. So it is 20 to 12 now. We will resume at 10 to 12, please. Court adjourned.
what do they actually, what is it? Yeah,
Can we settle down?
We resume after the short break. You may proceed, Mr. Ramukhane.
Thank you, milady. I will attempt to be brief in my reply. There are really 4 issues I need to deal with. At first, we heard a lot about motives, politics, what Mr. Swartbooi is trying to do with this particular case. And we say this very simply. This is a court of law. The issues, the context might be political, but the court must decide it within the 4 corners of the law. Whoever wants to do whatever, that's their own business. But the court must decide the issue as the law in fact provides. The second is, again, there was a clear conflation between diplomatic immunity and state immunity. And we were essentially accused of trying to get away around the Diplomatic Immunities Act by not citing the head of state. I began my address by referring to an authority in our heads, Fox and Weber, that explains that particular distinction. I then referred the court to 3 conventions of international law, the 1961 Vienna Convention, the 1963 Vienna Convention, and the third being the UN Convention on Immunities. All of them set out a clear distinction between heads of state immunity or personal immunity and immunity that attaches to the state. The idea that when you have to sue a state, you have to cite the head of state in doing so is with respect a ridiculous one. Is with respect a ridiculous one. The reason we say so is, 1, as we submitted earlier, heads of state immunity attaches to the person because of their official role in the discharge of their duties. It is obviously attached to that because they are acting on behalf of the government, in the same way that a diplomat does. Whereas state immunity is a permanent one that attaches to the state, contingent on statehood. The two are not the same. And that distinction is made out quite clearly in the Germany v. Italy decision. We've heard a lot about that. The court will read it on its own time and reach its own conclusion about the finding there. But the thrust of the point is every single authority relied on by the respondents. I'm sorry, Belade.
Murmuring in court, and that's very distracting. So the court is trying to follow what you say. Just requesting the gallery to just tone down. Thank you.
And so the point we make is the Al-Bashir decision of the Supreme Court of Appeal dealt with personal immunity. You recall that the facts in that particular case was that President Al-Bashir was attending a conference in South Africa. At the time, there was an arrest warrant out in his name, issued by the International Criminal Court. The question before the court was, did South Africa have an obligation to arrest him? The issue of state immunity, of diplomatic immunity, arose in that particular case, because the argument that was being made by the South African government was President al-Bashir is a head of state, and therefore South Africa cannot arrest him, and the court found that to be unconstitutional. Again, that decision makes it clear that there's a distinction between the two, and despite the fact that heads of state enjoy personal immunity, the Supreme Court of Appeal nevertheless found that the South African authorities should have arrested him on the back of the ICC arrest warrant. Similarly, the arrest warrant case, again, was about a head of state, the arrest warrant decision of the ICJ, all about personal immunity. And I'm grateful that my learned friend referred the court to paragraph 87 of the ICJ decision in Germany v. Italy, where that particular distinction is set out quite clearly. There, in our core bundle, at page 185, rather actually begins at 184. My learned friend took the court to paragraph 87, which is at the foot of the page, where the ICJ says this: the court does not consider that the United Kingdom judgment in Pinochet is relevant, notwithstanding the reliance placed on that judgment by the Italian courts in Farini. Pinochet concerned the immunity of a former head of state from the criminal jurisdiction of another state, not the immunity of the state itself in proceedings designed to establish its liability to damages. The distinction between immunity of the official in the former type of case and that of the state in the latter case was emphasized by several judges in Pinochet. The distinction is clear. And so what we simply say is, statehood does not vest in the person. It vests in the state. Namibia is a republic, and regardless of who the president is, who the prime minister is, who the minister of foreign affairs is, its statehood vests in it, and it is permanent. Then we were told about the distinction between criminal jurisdiction on the one hand and civil jurisdiction on the other. And we make brief remarks on that. The first is that the Genocide Convention applies to all issues, civil and criminal. The International Criminal Court, established by the Rome Statute, applies the Genocide Convention. The International Court of Justice applies the Genocide Convention. The one court deals with criminal issues, the other court deals with state liability. That is clear from the remedies that the ICA gave in Gambia versus Myanmar. It is clear from the case of South Africa versus Israel. In that, none of those deal with the question of criminal liability, but the Genocide Convention applies. And in fact, the court doesn't have to take my word for it. If the court looks at paragraph 42.2 of the respondents' heads of argument, they make a proposition about what happens in criminal law, and then they say this, which is quite revealing. They say, we submit that although the findings were made in the context of a criminal matter, the same principles apply to civil claims against the state. Absolutely correct. So the court shouldn't, with respect for this argument about what the distinction does, because on their own version, the same principles apply to civil matters. But further, at paragraphs 58 and 93, and Justice Diago, this is to the question that you had put to my learned friend about the distinction between what is the question on procedural law and what is the question on substance. In other words, what's the value, the merits of the issues on the substance, on the merits to the procedural question. And the ICJ answers that in two paragraphs. Paragraph 58 and paragraph 93 of its judgment. '58 and 93. At 58, the ICJ says about that particular question that this is at the end of the paragraph. I'm reading at page 171 of the core bundle. The court says, moreover, as the court has stated in the context of personal immunities accorded by international law to foreign ministers, again, personal immunities, the law of immunity is essentially procedural in nature, and the court refers to the arrest warrant decision. It regulates the exercise of jurisdiction in respect of the particular conduct and is thus entirely distinct from the substantive law which determines whether the conduct itself is lawful or unlawful. Then it says at paragraph 93, which is on page 187 of the core bundle, and I'm reading from the middle of the paragraph. The ICJ says, the rules of state immunity are procedural in character and are confined to determining whether or not the courts of one state may exercise jurisdiction in respect of another state. They do not bear upon the question of whether or not the conduct in respect of which the proceedings are brought was unlawful or lawful. So again, what the merits have to say about this is entirely irrelevant to the question of jurisdiction.
With looking at the requirements for edictal citation, the first one in Rule 12 sub 2 is to look at the nature and extent of the claim. That is where the question was directed, and not so much about the merits of the wrongdoing in the jurisdiction aspect.
Yes, yes. No, I apologize, I misunderstood the question. Our submissions on that is quite simple. We've made out in the application, both for joinder and edictal citation, why it is that we seek for Germany to be cited. We speak about their direct and substantial interest. The respondents, as we understand, say Germany does have a direct and substantial interest in the claim, but they say that they are immune. And so there is no dispute between the parties that Germany does have a direct and substantial interest. The only question is whether immunity applies to that. And then last two issues, maybe three. Deputy Judge President, you asked me earlier about the distinction between Rule 11 and Rule 12 and whether there's a particular conflation between the two. As we read it, the two are to be read together. Rule 11.1a, which deals with service outside of Namibia, says that if you're going to be seeking to serve outside Namibia, you need the leave of the court. And then 12 then says service outside of Namibia must be effective in terms of Rule 11. So the two are to be read together. And then the last two issues are the questions of joinder the irregular step proceedings and costs. On the irregular step proceedings, the point that we make is a simple one. There's an acceptance by the respondents that there are parties who are not before the court, who should be before the court. With the exception of Germany, I think Mr. Kauta said there are 27 parties. All we are asking for is this: once a party has been joined to a proceeding, it needs to make an election about whether it joins common cause with the relief sought by the applicants or whether it opposes the application. But you cannot be, on the authority that Mr. Kauta relied on in African Transformation Movement, be a respondent that supports the application. And so room has to be made. Once there's an acceptance that joinder has to be ordered in respect of the traditional authorities and several other respondents about what is to happen after that. That's the only point we make on that. And our criticism against the respondents is that we informed them of that before service of the answering affidavit. And there was attempts made at a pre-hearing or case management or meeting between the parties to resolve that particular issue as required by the rules of the court, and that was simply ignored. That's our criticism on that. But we're saying something has to regulate the future conduct once you accept a joinder, both on the traditional authorities that we seek to join, but also of the Prime Minister and the Minister of Defense, that they criticize us for not joining. But once those parties are in, what then must happen? That's really what we are asking for. Lastly, on costs, we've made our submissions in the heads on this. We say, with the authority that we've relied on from this court, Shangala versus President of the Republic of Namibia, that buy watch applies in these kinds of proceedings. Justices, unless there are any other questions, those are our submissions.
Any questions? No.
Apologies,
No,
just one last issue, I'm just reminded of it now, about this issue about, is the finding on jurisdiction a final one, is it a preliminary one? Our only answer to that, Justice Diaga, is that the court must apply a dictal citation in the ordinary way it does. Once a party is served by a dictal citation, it obviously has the opportunity to say whether it should be joined to the proceedings and raise other issues. That's all we say. But the dictal citation depends on a finding on jurisdiction. But that doesn't close a joined party in later proceedings from raising the issue. That happens in any other dictal citation application. That's all we say.
Did you answer the question whether is it allowed in law to determine jurisdiction on a prima facie basis or not? I think that was the issue that was taken up with Mr. Heathcote.
Well, the issue here is that the court is at liberty to say, for the purpose of the dictal citation application, we hold the view that Germany should be served with the application. We do not determine with finality whether Germany is in fact immune from the proceedings of this court, and it can decide that at the joinder application. But the service of a party through a dictal citation always turns on that particular question. And the reason is because it's created to carve out ridiculous applications. Right? It's a knockout rule that if the court says that this is not a party that should be here, then it should in fact be edictally cited. That's all.
Sorry for that.
I'm happy to provide a short note to assist the court with that particular issue. I don't have an authority that comes particularly to mind, but the rule sets out that for a dictal citation there has to be jurisdiction. But equally, we know from how this court operates and how court practice, in fact, is that once an edictal citation is served, a party is not foreclosed from raising an issue of joinder.
Right. Well, we would like to see the additional note.
Very happy to provide that to the court.
By when are you going to file it?
My apologies, my lady.
By when are you going to file it?
We're happy to provide it by this Friday.
Friday.
Yes.
By close of business. Obviously, the opposing party will have to have the opportunity to respond thereto should they wish to do so.
Indeed, my lady. Yes, we'll confine ourselves to that issue. There are other issues the court wants to deal with. We'll happily do so, but we'll confine ourselves to the issue about what is to happen if the court is only dealing with the edictal citation application without deciding on the joinder of Germany. And that, of course, excludes the other parties where it's common cause that they should be joined.
Mr. Heathcote, should you wish to apply to this, You'll do so by Tuesday?
Tuesday is fine, thank you.
Tuesday is? 14. Well, in that case, this additional note must be filed by close of business on Friday, the 10th of October, and a reply thereto, if any, to be filed by close of business on 14 October. Thank you.
Thank you, Lady.
Council, that would then be the end of these proceedings, and at this stage the court will then reserve ruling on the ancillary issues until 18 November 2025 at 10 o'clock in the morning.
Please, my lady.
We are adjourned.